Hi, I'm Mark Schroeder from GSHC Surrogacy Agency, and today we're speaking with David Cole to talk to him about the legal aspects of surrogacy in Texas. David, how are you doing today?
I'm doing great, Mark. How are you?
Doing very well. Thanks for asking. First question, what happens if a surrogate does not use a surrogacy attorney?
In Texas, it is not required that a surrogate has an attorney. However, I think the process of working through a gestational agreement and making sure that the surrogate is adequately protected would serve the surrogate if she had an attorney to represent her.
And can you explain what a surrogacy contract is and why that's important?
In Texas, we call it a gestational agreement. A gestational agreement is the agreement that's entered into between the intended parents and the gestational surrogate. The gestational surrogate's husband, if she's married, would also be a party to the agreement. The agreement provides, first and foremost, that the child that she is carrying would be the legal child of the intended parents. The agreement will also provide for her financial protection through the process. Her base rate compensation, sort of the what ifs financially, like what if she has an extended bed rest or had some other invasive procedure. And then the agreement also provides for how to make a decision. How will the parties make a decision? If there were a situation where the child had some sort of fetal or congenital abnormality and the intended parents were requesting a decision or requesting that she terminate, the agreement has adequately worked through how we're going to make that decision.
What were to happen in the instance where the intended parent or the surrogate does not follow the gestational agreement?
In Texas, a gestational agreement is enforceable when it is validated. If a party, a gestational surrogate or the intended parents, were to breach an agreement after validation, then the aggrieved party could bring an action for damages or what's called specific performance in the event the agreement's been breached. The first thing the intended parents would do would be notify her of the breach and give her an opportunity to cure. So it's like, you need to stop smoking. Another thing that they could do would be to bring what's called injunctive relief. So that would be bring a suit in court where they're asking the judge to enter an order telling her that she cannot smoke. And then the third thing they could do would be bring a damages case against her if they could show economic damages caused by her smoking. So maybe the child was born with a really low birth weight and intended parents could try to allege that that birth weight was a reflection of her smoking during the pregnancy.
David, what can intended parents in Texas expect to pay for the legal services for surrogacy?
In Texas, a gestational agreement will cost, I'm going to say somewhere between $750 and $1,500. The intended parents are responsible for the gestational surrogate's attorney fee to review that gestational agreement with her. And that would also be a fee of $750 to $1,500. So in the drafting and negotiation of the gestational agreement, this is a pretty wide range, but I'm going to say somewhere between $1,500 on the low side and $3,000 on the high side. If the gestational surrogate achieves a pregnancy and we are validating that gestational agreement to establish parentage in the intended parents, fees range, like court costs and filing fees are typically $350 to $700. And then legal fees generally are between $2,000 and $3,500. I'm giving you some wide ranges there because there are, for instance, if you have a Chinese intended parents, it's more expensive. If you have intended parents who are working with the surrogate is maybe their sister, the intended mother's sister, then the fees are less.
David, can you explain some of the advantages of pursuing surrogacy in the state of Texas?
Surrogacy in the state of Texas is codified, meaning we in Texas adopted the Uniform Parentage Act. We have adopted this very standard protocol for gestational surrogacy. So I think primarily the advantages in Texas are that we have this sort of a codified approach to it. Additionally, honestly, prices in Texas are less. So fees, legal fees, surrogacy fees, even medical fees in Texas are less. So I think primarily those are your two advantages. We have a codified and well-recognized process that's accepted in every district court across the state. And we have sort of just the way the fees have worked in Texas thus far is there is some price suppression in our state.
What would happen if the intended parent or the surrogate's marital status changes during a journey? Does that impact the surrogacy process at all?
If a gestational surrogate is single and she becomes married during the surrogacy, there is really no effect. So the man that she becomes married to is not a party to the gestational agreement. He's not a party to the legal process. If a gestational surrogate is divorcing, that does create issues. So if a gestational surrogate was maybe living in a more rural county and had filed for a divorce, it could greatly complicate the process for the intended parents. We have had this happen before, and what we try to do is we try to get the order entered that establishes the intended parents as parents before a divorce is filed. Sometimes that's been successful, sometimes it hasn't been. With respect to intended parents, if intended parents are married and enter into a gestational surrogacy agreement, and then they are divorcing, the divorce laws that would apply in their state of residence. So if they lived somewhere else, if they were in Nebraska, then the rules of Nebraska are going to apply to their divorce. If they were living in Texas, their divorce would be stayed, meaning it wouldn't happen. They could file for a divorce during the pregnancy, but their divorce would not be granted until the child had been born. It would be exactly as if the intended mother were carrying the child.
Why is a surrogacy agency important to the process?
I think a surrogacy agency is vitally important to the process. I feel like there needs to be an intermediary who stands in between the parties. We do lots of independent surrogacies. And I find that an independent surrogacy is much harder for the gestational surrogate, and it's much harder for the intended parents because nothing stands between them. It's nice to have somebody in between who can sort of talk one side down, talk the other side down, maybe could talk about financial questions that may come up on one side, talk about maybe conduct that might be coming up on the other side. And that's not even to mention the vetting process that happens. I think there is an amazing amount of value in having a person, an agency who has had multiple repetitions with intended parents and multiple repetitions with gestational surrogates who then can match couples together in a way that serves the gestational surrogate and serves the intended parents.
Can a surrogate decide to keep the baby?
No, a surrogate cannot decide to keep the baby. The physician can't transfer the embryo until the legal process, which sets forth the framework for establishing the intended parents as the parents, has happened. So when the surrogate delivers the child, she is not delivering a child with whom she has a legal relationship. So the gestational surrogate may not make a decision after delivery to keep the child.
After the surrogate signs the gestational agreement, what are the next steps for her?
After the gestational surrogate signs the agreement, then it's incumbent upon the attorney to send legal clearance to the clinic. And what that does is it authorizes the clinic to move forward with the embryo transfer.
What is a pre-birth order and when is that established?
A pre-birth order is the order that's entered following the execution of the gestational agreement, which establishes the intended parents as the parents of the child and validates the gestational agreement. When you enter a gestational agreement and that agreement is fully signed by the parties could move forward immediately to validate that agreement and establish parentage, even if there has not been an embryo transfer. If we achieve a pregnancy and we are getting to about the end of the first trimester, that's typically when we start the process of validation and establishment of parentage. I'm going to say in 90% of our cases, the intended parents are validating at the end of the first trimester.
Can a pre-birth order be established after the delivery?
A pre-birth order cannot be established after a delivery. Now, a parentage order could be entered after a delivery. We really want to have an order in place by 20 weeks. If we don't, let's say we're at 22 or 23 or 24 weeks and we have a premature birth, we can't validate the gestational agreement, but the court has allowed us to enter a parentage order. We always want to make sure that we have an order entered prior to 20 weeks.
Whose name will go on the birth certificate?
With a validated gestational agreement, the intended parents' names will go on the birth certificate. So in any birth certificate that's created through gestational surrogacy, the parent chooses whether they want to be called the parent, the father, or the mother, and they check a box off, and then their name would be provided in that box. So if an intended parent is single, then that person goes on to the birth certificate as either the mother or the father, and then the other space is left blank. The gestational surrogate's name does not go on the birth certificate.
Can a surrogate select her own attorney for the legal process?
Yes, a surrogate can select her own attorney for the legal process. I just think that it's important to use someone who has repetitions. There are so many nuances to the contracts. I mean, and I've been doing this for, over 20 years, and I still read contracts and I, see new things. So I just think it's important to have someone who has had repetitions. But yes, a gestational surrogate can pick their own attorney.
Does your office work with international intended parents?
Yes, we do work with international intended parents. I think probably about 35, 40% of our practice is international intended parents. So all the same rules apply. For Texas to assert jurisdiction, obviously the gestational surrogate has to be a resident of Texas, but there is no other residency requirements. So we can work with couples from any other state or any other country.
And David, what happens if the surrogate suffers complications during the pregnancy?
There are a number of things that could happen during a pregnancy medically that we may need to think about at the point of drafting the agreement. So for instance, if a surrogate were to have, let's say, an extended bed rest at some point during the pregnancy, then the agreement needs to provide for how she's going to be protected financially during that period, and how she's going to be able to maneuver through just the ordinary decision-making that she has to make in her household. The goal here is that she deliver a healthy child. So we want to set up, from the intended parent standpoint, you want to have an agreement that is going to adequately protect that process. The process of her being able to successfully maneuver through a pregnancy and deliver a healthy child. And if she has a complication, we want the agreement to provide for how that's going to happen. The goal is to have an agreement that's going to adequately provide for how to answer all these questions.
In the state of Texas, do the intended parents have the option for a termination or reduction in the event that there's a complication during the pregnancy?
So Texas is obviously we are a politically conservative state, and termination of pregnancy is the decision of a mother less than 20 weeks. So if she is less than 20 weeks, she may make the decision to terminate a pregnancy. A gestational agreement can set forth parameters which are going to maybe limit or compel her ability to make that decision, but it is very unlikely that a gestational agreement would be enforceable. So what is important on this issue is that the parties, at the point of execution of and drafting their gestational agreement, that they are talking about this issue in specificity. They are really talking about termination of pregnancy and making sure that the parties are cohesive on the way they think about the issue. We don't want a case where we have intended parents who would be wanting to terminate in the event of, say, a diagnosis of Down syndrome, and then we have a gestational mother who would not want to terminate in that event. That's not a good match. The way you solve that is at the match. You don't solve it with a gestational agreement, at 19 weeks and trying to make that decision.
This has been a conversation with attorney David Cole. David, thank you so much for your time today.
Mark, thank you. I enjoyed it. And we're a law practice in Dallas, Texas. You can find us at www.artslegal.com. Thanks very much.